I've noticed recently that there is a rather disturbing and quite serious misunderstanding of the relationship between British law and international law. I won't go into the details, but we all know what the pressing issue is in the media that has brought this up. And it's actually quite worrying because it demonstrates a very serious misunderstanding of the British law and the British Constitution. We should all be taught this in schools, but we weren't. So this little talk here, I've got no notes, so I'm going to do it off the top of my head, is going to be me trying to find the problem, define it, diagnose it, and offer some corrections. Okay, let's dive right in. What a lot of people seem to think is that when the United Kingdom signs up to a treaty with another country or an international organisation, that imposes obligations on the UK and obligations on the other party. But that when the UK passes its own laws that directly contradict or conflict with the provisions in the treaty, that this new conflicting law to the treaty is either illegal or invalid or will somehow incur the wrath of some vague internationalist entity. This is all wrong. Okay? It's utterly wrong. The reason why it's wrong is because it's asserting that international law is superior to domestic legislation. This is totally wrong because the fundamental principle of the British Constitution is a concept called the supremacy of Parliament, which basically means that Parliament is the ultimate source of law in the UK. It creates the highest law, and nothing can stop Parliament from legislating about whatever it likes. Not even Parliament. Parliament cannot pass a law that says all future laws regarding a subject whatever are controlled by this. It can't do it. It is an absolute legislature. But the idea that when the UK signs up to a treaty, and if we make a new law that conflicts with the treaty, the new law is invalid or void or somehow enables the courts to set it aside, is totally wrong. Let me explain how treaties actually work. Oh, and another reason why it's wrong is that it implies that once a country signs up to a treaty, it's locked into that treaty forever. That's completely wrong as well. International law has long since recognized that sovereign states have the right to terminate treaties essentially when they want to. It'll either be a provision in the treaty that describes how termination can be done, or if not described in the treaty, it'll be in the Vienna Convention and the law controlling treaties. And if it's not in that, it'll be in international customary law. And if it isn't that, it's just de facto. If it's clear that a country is going against a treaty, other countries can say, well, they're not interested in adhering to the treaty anymore. They've thrown it away. They've terminated it. But the way the UK does treaties is very different than the popular notion I've just described. The power to create treaties, I'm pretty sure, it was an emanation of the royal prerogative. So originally it was an ancient power of the crown. That was then delegated down into the executive. I'm pretty sure it's the Foreign Office, but generally it's in the purview of the Foreign Office. So the Foreign Office will then make a treaty with another country or an international organization, whatever. And this is the important point. The UK is what is known as a dualist jurisdiction, as opposed to a monist jurisdiction. What is a dualist jurisdiction? A dualist jurisdiction is where international law has no existence domestically until a treaty is incorporated into domestic law. This is why, from the Constitution of the UK's point of view, there's two kinds of treaties. There are unincorporated treaties and incorporated treaties. A classic example from memory would be the European Convention on Human Rights. We signed up to that back in like 1950 odd or whatever, but that only became that was only brought into our own domestic law via the Human Rights Act in 1998. So the European Convention on Human Rights was an unincorporated treaty for 40 odd years. So what does that mean? An unincorporated treaty, it may contain rights, obligations, whatever, but those rights and obligations have no effect in UK courts until it's incorporated, if it's ever incorporated. Unless through the process of statutory interpretation, this is a big topic, there are things called presumptions of statutory interpretation, whereby if the law is unclear or ambiguous, and has more than two or more meanings, the courts have a series of rules that they can pull up, which have developed through case law, to fill in the gaps of meaning. And one of these presumptions is that Parliament will, when it drafts its legislation, will, as so far as possible, adhere to international obligations and treaties, irregardless if they've been incorporated or not. So if a statute is vague, the courts will imply or impose this idea that if it's vague, and if one interpretation breaches the unincorporated treaty, that is wrong, and that the ambiguous provision, should be read in a way that upholds international obligations. That's about as much as you can get. However, if the statutory provision is clear and clearly contradicts the treaty, because the treaty is unincorporated, the domestic law is untouched. This is the law of the land. So what is incorporation? Incorporation is basically turning the treaty into an act of Parliament. That's exactly what the Human Rights Act did. The European Convention on the Human Rights is actually in Schedule 1 or 2, I think. It's just copied and pasted into it. And the Human Rights Act just said the treaty is now the law of the land. That's all it did. So when you incorporate a treaty into domestic law via incorporation, it is essentially no different than any other act of Parliament. So what happens when a new law comes along that conflicts with the incorporated treaty? Well, back to the concept of the supremacy of Parliament. Because nothing can stop Parliament making any law that it likes, when two laws conflict, the new law is seen to have overwritten the former. This is called implied repeal. It's that simple. So if Parliament makes a new law that conflicts with a treaty that was incorporated, the new law overwrites or has supremacy over the old law. It's not illegal, it's not void, it just replaces it. It's that simple. Anything else to add? Yeah, so this concept that the international law imposes a binding obligation on the Parliament is nonsense. If Parliament does go against an international treaty via its own new legislation, other countries might get angry, they might send letters of protest, but it is well recognized within international law that will be regarded as essentially a termination, what's the phrase? A constructive termination. So the UK, it's legislating against this treaty. From the UK's point of view, it's terminated the treaty, it's not interested. That's it. Treaties are not like contracts, where if one party breaches a contract, you can take them to your local county court and sue them. It doesn't work like that. So this nonsense that Parliament must adhere to international law all the time, and if any new act of Parliament conflicts with international law is void or invalid or illegal, is nonsense. An act of Parliament, by definition, cannot be illegal. It's like a married bachelor or a square circle. You cannot have an illegal law. It's absurd. It's a bit like if someone argued that the repeal of the sodomy laws the old 16th century laws that outlawed homosexuality, if someone argued that that's like saying that the repeal of the sodomy laws was illegal because it breached the older law. No, it replaced the older law. It didn't breach anything, and it's a valid law. Just as the sodomy law, immoral from our point of view, was a valid law. You must never get confused between a valid law and an immoral law. The law isn't just that. Parliament has passed all manner of absurd and obscene legislation, but it's all been legally valid. And courts do not set aside statutes because they don't like the moral content of the law. Sorry, that's not the role of judges. So, to summarise, I forgot what I say. Summarise. The law of Parliament is supreme. It cannot be barred or impeded by any other source of law, not even treaties. And if it makes a new law which conflicts with a treaty, either incorporated or unincorporated, that's now the new law. And it's the standing law until another law replaces it, and so on and so on and so on. It's that simple. Okay, I think we've covered that.